morning. Be seated. Now is the time set for oral argument in cause number 1 CACV 140252, Great Western Bank versus LJC Development LLC. For counsel's information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, you'll be able to see yourself on YouTube in a couple of weeks. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left, and appellant, if you wish to reserve any time for rebuttal, please let us know so we can try and keep from taking up all your time. However, ultimately that is your responsibility to reserve and preserve that time. We've reviewed the briefs this morning. We've conferenced the matter this morning, so we are well aware of the facts and issues attendant to the argument, and hopefully that will give you some sense of how you can orient your argument to your best interests. And to both counsel, when you come to the podium, I would ask that you state your name, who you represent, and with that, counsel, if you would please.
Thank you. Good morning, Your Honors. May it please the Court, Scott Jenkins, Jr., with the law firm of Quarles and Brady, on behalf of Great Western Bank, which was the successor in interest to Tier 1 Bank. Your Honors, this is unfortunately another case, dealing with a real estate development arising out of the Great Recession of 2008 through really 2010. As the Court's indicated, you reviewed the brief, so you're aware that there's really two agreements that were in place between Tier 1 and Cedar Ridge Investments, LLC, the borrower in this case, that are really at the heart of this case. The first one was the initial acquisition and development loan that was done in May of 2007, entered in between Tier 1 Bank and Cedar Ridge Investments, and the purpose of the A&D loan was basically to put in the infrastructure for this 50-lot development up in Flagstaff, Arizona. Again, that was done in May of 2007. What followed after that is the second agreement that's the subject of this case, is the loan agreement. It's referred to constantly throughout the trial court as the guidance line that was executed in January of 2008.
Counsel, isn't that typically the way these developments proceed?
Exactly.
You have an A&D agreement, and that gets us up to the point where we're ready to start building and selling houses.
That gets I'm sorry.
No, that's okay. And the second contract then, once everybody gets a chance to go back in, look at what we've got, look at where things stand, see if everything's been done, as my mother would say, according to Hoyle, whoever he was, then you start lending on the construction loans for the residences themselves, correct?
You're exactly right, Your Honor.
And this was a loan agreement?
You're right, Your Honor.
Thank you.
Okay. That's the title of the document, and really that's why we're here. The issue before the court today is because the trial court actually granted summary judgment in favor of the bank, Great Western Bank at the time, which was the successor in interest, based on the past due amounts on the acquisition and development loan. But then at trial, the trial court found that there was a breach under the guidance line and applied an offset in favor of the loan guarantors for the full amount of the A&D loan.
We keep calling it the guidance line. There is a letter dated January 9, 2008 that talks about guidance line and curiously has guidance line in quotes for no reason that I can discern, except maybe to suggest that that's a colloquial or somehow humorous term that isn't really a term of art. But then the day after, we don't have a guidance line. The day after, we have a formal loan agreement. And it seems to me that the entire premise of each of your arguments is the notion that the loan agreement didn't require your client to do a thing. Is that correct?
That is correct, Your Honor.
That's a lot of wasted paper for an agreement that requires nothing, isn't it?
I understand, and the difference is.
Wait. How is that not? And I would like you to wrap this into your answer.
Sure.
How is that not an illusory contract?
Essentially, it's an executory contract. There's obligations due to on both parties on both sides. I mean, if you look, Your Honors, it's basically, is it a committed loan agreement? Is it a committed loan, like a line of credit, where the money's available to draw down, where you don't have to ask for permission, or is it an uncommitted construction facility?
When the agreement used the term commitment, that referred to just that, a commitment. But you've answered my question and Judge Jones's question in two ways. In my question, you said the contract doesn't require your client to do anything. And in response to Judge Jones, you said it's an executory contract and each party has to do something. Which is it?
I think that's my answer was consistent, and here's how. If and in this case, you're 6 months into the deal. The loan was signed in January of 2008, expired on December 1 of 2008. And here we are in July, and nothing has been done. They're still not even done with the infrastructure. They're 63% of the way done in August.
But they were still within the confines of the schedules that have been established for that?
That I think there's conflicting testimony and evidence in the case that they were. I think as far as the infrastructure, they were moving forward with the infrastructure, but they were way past, the timeline in which they were supposed to be done.
Didn't your expert say that they'd made good progress? They were in good shape?
It wasn't our expert. There was an inspector that basically goes out and checks on the condition of the property and where they are.
Who does he do it for?
He does it on behalf of the bank.
And so the guy you sent out said, they're in good shape, they're on schedule, they'll be fine, they'll be ready to go.
Your Honor, if you look at it, what they're doing is basically saying, here's A to Z as far as the infrastructure for the development. Where they were at that particular time, they're moving towards Z, but I don't think that there's commentary as far as whether they're on time or not, or whether...
Let's get back to what actually happened here. There was no default declared. There was no determination by your client that this developer is so far behind that the agreement has to be canceled. Your client just decided not to make loans. Right?
My client looked at the situation in July of 2008 and the market, and circumstances of the Arizona residential market and the national market, and decided, in looking at the project,
it would be prudent to breach its agreement.
Obviously, that's the way the trial court found. We believe.
Well, look, the agreement says, and even the guidance line letter says, that your client will look at and approve or reject loans on a case-by-case basis.
Correct.
It never did so.
Correct. Our position is...
And that's not a breach. Why?
That's not a breach because if you have the discretion basically to sit back and look at loan applications coming on a case-by-case basis, and you have the discretion to reject those loan requests, whether it's values have plummeted and you're no longer fit within the loan to value, whether it's being behind schedule, whether it's not having permitting, they have the right to say no to the loan request.
Had so much discretion that the whole thing meant nothing.
No, they had the right to withdraw the line of credit. If they have the right...
They advised them of that. When did they advise them? You're so far behind. You have failed so miserably in the A and D portion of this. You have done X, Y, and Z to the point where we cannot go further with you, and we are therefore terminating the contract. Where did they do that?
No, they didn't. There was not any notification.
What about the language of the agreement to make and take loan that says, subject to the terms and conditions set forth in this agreement, lender agrees to make the loan to buyer, each such loan to be used by borrower for the acquisition of a lot and for subsequent construction by borrower, shall make the loan. Yes. It doesn't say, it doesn't say that if we sit back and look at all this stuff in very, ephemeral whatever terms, that no one can put a hand on now and say this is where the breach was or this is where the problem was. You couldn't even assert a default. How can you say that you complied with the portion that said lender agrees to make the loan?
The first part of that is subject to the terms and conditions of the loan agreement.
Which conditions did they breach?
They didn't comply with any conditions. They never made a loan request and never were in a position.
Because you never gave them the chance to.
Well, that's obviously their argument.
But let's talk about yours. What did your client do? What steps did it take to comply with this agreement? Is there one step that it took to comply with this agreement?
Well, the unfortunate facts in this case is the loan officer in this case passed away shortly after sending the email.
The agreement was not with the officer.
No,
the agreement was with the bank. So what steps did the bank take to comply with the agreement?
They comply with the agreement from the standpoint of there's no obligation on behalf of the obligations are from the borrower to come to the bank and check off the 15 or so boxes that they have to check off before they make a loan request. So the bank...
Borrower ever ask for a loan to build a house?
No.
Did they ever get the chance to ask for a loan to build a house?
Our position is they were never... no. I mean, from the standpoint of they're now in July, they have 4 months left under the term. They were 63% of the way done in infrastructure. There was no way. The bank looked at the economy and said, we do not want a situation where there's going to be a partially completed development, and we drew the line, believing that due to the fact that they had an ability to approve loans and they were going to deny those loans on a case-by-case basis, that they could just be upfront with their customer, approach them and say, listen, we are not going to be your construction lender on this project.
Despite the fact that we have an agreement to be. Now, I understand that a bank might look at the overall economy and decide that breach is more efficient than performance, and that's allowed, but you have to pay damages if you make that decision. Is there a contractual condition that says if we think the economy's headed south, we can simply cancel this agreement?
There's not a specific provision that says. There is a material adverse change provision in the agreement.
But they didn't invoke that.
They didn't. Okay.
So why is this then not simply a case of, the euphemistic legal term is efficient breach?
Because it's still our position, and I understand what you're saying, Your Honor, but the position is that they had discretion. If you have discretion to deny loans on a case, this is going to be a situation where it was a catch-22 from the bank. From the standpoint, if they
catch what?
I'm sorry, catch-22 situation.
Catch-22.
So let's just play this out. So the bank sits back and says we can't unilaterally terminate, use our discretion, get in front of this, notified our borrower that we're not going to be the lender, but we'll wait for loan requests to come in. And when they come in, they decline them in their discretion.
They have to do so in good faith.
Absolutely.
I mean, it would. That's a little bit like saying a judge who has discretion to make 18 different calls during the day doesn't have to show up to work. Just phone it in and say denied.
No, I disagree with your analysis there. That the absolutely in good faith. There's no evidence in this case that the bank entered into this agreement in the beginning thinking they weren't going to make loans.
No. But I guess my point is, if they are using their discretion as a justification for cancellation, then what they're saying is no matter how good a job you did, borrower, no matter how sterling the application for a single lot, we could have denied it anyway, so we're just going to deny them all right now. And I don't see how that squares with good faith.
I don't think that's the facts, though. It wasn't, hey, we just don't like you anymore, we're not going to lend to you. It was a realization of what was. Let's flash back to 2008. We're in the summer of 2008, shortly thereafter in the fall with the stock market crash. I mean, things are absolutely uncertain, and the real estate market is an absolute shambles. So it's not like things were banging away on all cylinders, and they decided
to... the first one to have made an investment choice that it regretted in the Great Recession. That doesn't mean that you get a pass. I mean, your client certainly didn't give its borrower a pass when it came time to foreclose on the land, right?
Well, Your Honor, I disagree from the standpoint the bank's not an investor in this project, it's the lender, and it has to minimize its risk.
Anything a bank does with a loan portfolio is to an extent an investment, but I guess when you say, boy, this deal looks really bad, we've got to pull out, the borrower didn't have an equal opportunity under these agreements to simply say, we relied on your agreement to make loans, you didn't make loans, so now you shouldn't be able to foreclose on us. That discussion never happened.
They never made that argument. They never said a word. They didn't even object to the revocation of the line until after bankruptcy was filed and then a guarantor lawsuit was filed.
I take it inherent in your position is the notion that the foreclosure was appropriate.
It absolutely was appropriate.
Despite the fact that your client, the developer here clearly relied on your client's commitment in moving forward, your client revokes that commitment and then manages to take the property. Do you see anything about that could run afoul of the covenant of good faith and fair dealing?
If those were the facts, I do, but I would disagree with you that there was a commitment. It was an uncommitted loan facility, and as we started off with Judge Jones, this is not unique. to the lending world to have here's our preferred construction financer for the vertical construction of homes. And if you think about it, Your Honor, they signed up for a loan agreement in January of 2008. And if you're really saying that that was a commitment to make loans in August, September, October, regardless of what happened with the market, what's going on with the project, that they are stuck, that's a line of credit. And the agreement specifically says it's not a line of credit.
I think what I'm suggesting is that they're stuck with the terms of the agreement that
guide
the exercise of their discretion. If they get an application to build a really bad property for a really bad buyer, that would be a reason to turn it down.
Right.
But I think what you're saying is, again, no matter how sterling the application, they simply didn't have to do it, which doesn't sound like discretion in good faith. That sounds like, as Judge Jones put it, an illusory contract.
And I would argue that if they did do that and there was a sterling application that they denied just because but that's not the facts of this case. They denied it because the project was behind and the real estate market is in shambles, and there was absolutely no application on the horizon for dealing with the property.
So is this an illusory contract or not?
No, it's essentially an executory contract. They could come and submit loan applications to the lender, and the lender looks at it on a case-by-case basis. If you look at the pre-loan documentation, every term sheet says that specifically. There is no confusion. These are sophisticated parties doing real estate development loans. Everyone knew exactly what this argument was raised for the first time after the foreclosure, after the bankruptcy, after the foreclosure, and during the connection with the loan guarantor suit.
Do I have the facts wrong? Did Tier 1 not decide that it was going to make no more loans for construction in Arizona before it canceled this agreement?
It did make that. That was in that email.
So this had nothing to do with the project. This had nothing to do with the quality of any application. It had just decided flat out it wasn't going to make loans.
I believe the record, that's what the email says. I can't deny that, but I do believe the notes and the records and the write-ups.
So when we talk about project delays and 63% completion, that really doesn't get to the facts of this case, does it? If the decision's already been made, then your only argument is they had the right to make that decision.
Listen, I understand where you're coming from, Your Honor. I disagree. Your premise is...
But tell me why. I want you to persuade me if you can.
Absolutely. It's a simple notion of, is it a committed loan agreement? Is it a line of credit that you have an automatic right to withdraw? Or is it an uncommitted loan facility, which is the way these are set up? Because if you're looking at making loans 6, 8, 9 months in the future, okay, the bank needs to minimize its risk, and it had discretion to... Again, our argument is if you have the right to deny loans in good faith on a case-by-case basis, then you have the right to withdraw the line entirely. And if they didn't do that, we'd be right here.
So that's the logical crux of all of your arguments. If you have the right to make discretionary calls on a case-by-case basis, then you don't even have to do anything because you can simply collapse all those decisions in advance into one blanket denial. That's
in good faith. I agree that there's obviously an underlying good faith and fair dealing in every contract. What I'm saying is there's no evidence that they just woke up and said, we're done in Arizona.
So it's not guided discretion, it's just complete unfettered discretion. My understanding was if the application met certain requirements that the parties had agreed upon, then the loan would occur. And so you're telling us that's not the case?
Basically, under the agreement as drafted, it says two parts. One, that the lender has the sole and absolute discretion to review these on a case-by-case basis, and the borrower has to satisfy all the obligations under the agreement in order to make the loan application. I understand what you're saying. If they entered into the agreement with no intention of making a loan, we have a problem on good faith. If they woke up in March and said, I don't want to be in the business of construction lending, we have a problem. That's not the facts of the case. You have to look at where we were in the market and where we were with this project.
But didn't you, in fact, have a vice president, according to the records,
Sure.
who said even if we're going to take this type of lending out of the state, we're not going to do any more of these here, we're done with that. He said, then we need to find funding somewhere else and go ahead and fund this project because the project is legitimate?
The context of that comment was, so...
Bottom line is, they made the comment.
They made the comment, but it was in connection with post-December 1 discussions about going forward. It was not, let's go forward with the terms of the guidance line.
So the project was sufficiently legitimate that at least one of your vice presidents was saying, we need to do this thing. and the money was available, even if not under the program, if you will, and I don't know what the word is you would use, under the program we originally anticipated, but we need to find the money and we need to do this because this is a good project for the bank.
I think the analysis from the vice president after the fact, after it was pulled, into 2009 was looking at it from a purely economic situation. Are you better off with having 50 lots that are bladed and streets? I mean, drive around the outskirts of Phoenix. We all went there. We all saw, abandoned basically developments. He said, let's put some specs on and see if we can. It's more valuable.
Who's better off? That's really the question.
Everyone involved.
This is a loser. I doubt very much that the developer feels that it's better off as a result of your client's conduct. I don't think we'd be here today if it did. So the question then gets back to the covenant of good faith and fair dealing. If you're asking solely, am I, the bank, better off having a bunch of bladed lots, that doesn't meet the requirements, does it? Because if you deprive the other side of the benefit of the bargain, regardless of whether you feel you're better off after entering the bargain, you haven't complied with the covenant.
Your Honor, you're stretching what the comment in the case. It was not. It was basically, of course, the bank's looking at it from its perspective as far as losses. I mean, we have a situation, and I would absolutely disagree with you from the standpoint of at the time, because there was no complaint, there was no objection to withdrawal. They went out and sought alternative financing and couldn't get any, which highlights the point that it was prudent to withdraw.
But that's why they cut the deal with you. And my very first question to you was, isn't it the standard practice in these development construction cases that you have an A&D that's followed by a construction agreement for lending?
Right.
That's why they tied you guys up. They wanted to know that you'd be there for them when they were ready.
And they didn't tie us up. It was an uncommitted loan facility. I understand.
It was illusory. It really didn't get them the thing they were setting out to get.
I disagree. I think with the market conditions and where they were in the market, they had the right. But again, we spent a lot of time talking about whether there's a default. The bigger issue to me, in addition to, that there was not a default under the guidance line, is anticipatory repudiation. Because the evidence is absolutely clear. Even if they did make a strategic decision to pull the trigger because they thought the losses were going to be greater, they didn't comply with their obligations to establish anticipatory repudiation damages. They did not establish that they were ready, willing, and able to perform under the guidance line. And you just look at two things, and I know I'm running out of time, but the first one is on the date of the expiration of the guidance line, which I think we'd all agree, and I don't think they would deny, that there was no reasonable expectation to go beyond that date. That is the maturity. That is what the agreement says. That's the last day that you can ask for loan requests from us. On that very day, they signed an agreement with the city of Flagstaff that says before they're even able to submit building permits, that's construction permits, not CODs or COPs, that they had to put in a road for access, which they never did. So, I mean, at no point in this 1 year period were they ever in a position to be able to build. And so that's our position, that they were never in a position to build. Let's also look at the agreement. All they could do was 2 homes. They could build 2 specs. Before moving on to the third, they had to have a contract from a potential buyer. And in order to, move beyond that second one. So they were stuck. They could only build 2 homes. To go above that, they'd have to have a contract. And then finally, just the own testimony, Mr. Crowley, at trial, as far as, okay, if nothing changed and the bank sat by under your theory and your belief, and if they would have sat by and waited for loan requests to come in, what's the best you could have done in the circumstances? So nothing's changed. You come in with loan requests. They said 16. This is a 50 lot development. By his own admission, they could not perform under the terms of the agreement. So they're not entitled to a set-off because they never would have made it. So we get flash forward. Let's take his word that he could have done 16 homes, even though he would have had to have 14 sales contracts. He had 0 in July. You get to the point in time where it's now December. Now the bank is stuck, with a default situation with 16 potentially partially constructed homes. So it's really if you're going to find that there was a breach of the good faith and fair dealing, it's a no harm, no foul situation because they never would have made it. And if you look at the record of what happened, they did nothing afterwards. They went out, tried to find it. So, thank you.
Thank you, counsel.
Good morning. My name is Whitney Cunningham with the law firm of Aspey, Watkins & Diesel here on behalf of the defendants, appellees. With me in the courtroom today is Leo Crowley. Leo is a principal of LJC Development. May it please the court. The fundamental problem that we have in this case is that Tier 1 Bank, while it still existed, struck two contracts with my client. One for the acquisition and development, actually the refinancing and development of the infrastructure of the subdivision, and then secondly, a guidance line of credit according to their terminology. And by the way, their terminology is line of credit. I didn't make that up. That's Exhibit 9. Or, as we call it, a loan agreement, which is what the document is actually entitled, the entire purpose of which was to ensure that financing would be available for the vertical construction of homes as soon as the subdivision was ready to receive them. And
I think as the earlier questioning indicates, I understand that theory. But it is somewhat troubling that this all might be academic, right? That even if the structure of the agreements is not, at least in my mind, as appellant puts it, the facts surrounding the transaction are such that cancellation couldn't have mattered because construction couldn't have been begun within the effective period.
well, there was significant testimony developed on the issue of Cedar Ridge's ability and timing as it concerned pulling permits. And on pages 34 and 35 of our response brief, we quote John Crowley at length.
Who's John Crowley for the record?
John Crowley is Mr. Crowley, Leo Crowley's son. John was the developer on this project. He is an NAU graduate, business background, a successful developer who, even as this project was being tanked by the bank, had other successful subdivisions going on in Flagstaff. The trial court made findings of fact as to that point. And Mr. Crowley testified that essentially all that was left was to build an ABC gravel road and pull permits, a $15,000 road and $6,000 permits. And he testified specifically that this project was ready to pull permits in August, 1 month after the loan had been torpedoed.
Why didn't they request a loan? Why didn't they try to build a spec on this subdivision?
To pull a building permit to build a spec home would have required the installation of the fire road, the ABC gravel road. Mr. Crowley testified that he was in the process. Bear in mind, all throughout 2008, the developer was working on getting the subdivision ready. According to the bank's own inspector, progress was adequate. Mr. Crowley testified he was within 1 month of being there, being ready to pull that permit and get a spec home out of the ground.
As of?
August 2008.
And how long did they have for that A&D period? When was the end date on the A&D period?
The A&D period, I'm trying to recall if the A&D period was in repayment at that time. I believe it may not have been in repayment at that time. What I do know and what's relevant on the facts of this case is that it was not in default at that time, and the bank has conceded that point. The testimony was also developed, and the judge made findings of fact that the initial anticipation for the subdivision was that it would be able to sell 4 lots per month. Interestingly enough, even given the worst case scenarios in the Great Recession of 2008, the bank's own folks, their own appraisers and loan reviewers, indicated that they still anticipated that this project would have been able to build and sell 2 homes a month, which was, by the way, 1 more than necessary to service the A&D loan. So I think it's the United California Bank case that indicates that when you look at anticipatory repudiation and you talk about the fact that when the bank repudiated, was the borrower ready, willing, and able to perform? And the answer to that unequivocally is yes. And the court made a number of specific findings of fact on this specific point. Counsel wants to say, well, this was an executory contract. But here's what we know about the contract. Exhibit 26, which was an internal loan analysis document prepared 1 month before the loan agreement was signed in January 2008, indicates specifically that the entire purpose for the loan, I think it's worth reading, the entire purpose for the loan was the approval of $3.6 million at this time in order to ensure with an I, ensure that a lender will be available for construction financing. 1 month later, the loan agreement is signed. It has an end date of December 1. In the very clause that binds the bank to make the loans, that December 1 date is called out. My clients have the right to rely on the term of that agreement, and under the United California Bank case, what we know is our obligation was to be ready, willing, and able to perform within the terms of the contract, not at the whimsy of the bank. The bank doesn't get to wake up one day and say, well, yesterday we had a binding agreement and today we don't because you haven't pulled a loan yet. We weren't in breach, and we had until December to pull a loan. We had until November 30th of 2008 to make our first loan application, and we had the contractual right to expect that the bank would be there to honor it.
That's the date I was looking for and couldn't remember, counsel. Did they at any point advise you that there was a window that would have to be met or they would be voiding the loan agreement?
No, sir. From the date that the loan agreement was signed in January of 2008 until the date that it was pulled in July of 2008, there was no notice or other communication to that effect. The morning that the email withdrawing the loan was sent to my clients, there was a phone conversation between John Crowley and the bank officer, where the bank officer for the first time told my client, we've never considered this to be a binding agreement on our part or a committed facility.
What did they consider? I understand the terminology they want to use, but we keep asking, with our limited vision from what we have, is this an illusory contract? Can you address that?
Well, yes, I'd love to address that, Your Honor. The loan agreement doesn't use the term guidance line. The loan agreement doesn't use the term risk. The loan agreement does use the term discretion when it's talking about the bank's discretion to choose the appraiser, or the bank's discretion to accept or reject a title encumbrance, or the bank's discretion to accelerate the timing in which it will make loans. The word discretion is never used in the loan agreement in terms of the bank's fundamental obligation to make loans if the developer complies with its 36 or so requirements under the agreement. Now, the bank vice president at trial, in contradicting his own deposition testimony, testified in response to my question that there was quote unquote, exactly no difference for my client if it had this agreement versus if it didn't have this agreement in terms of whether there was an obligation on the part of the bank to do anything. In other words, at trial, the bank's testimony was my client was no better off than if it had merely walked in off the street to make a loan application in August of 2008. So you have this 15-page agreement signed by the president of the bank, approved by the bank's loan committee, from the president on down, I think every senior officer in the institution. And at trial, what they're arguing to our judge is it made exactly no difference. Now, if that's true, it is an illusory contract. There is no promise supporting it. And the problem is that our finder of fact, who was our judge, determined that the bank's position was without credibility. And one reason that it was without credibility was because the very vice president who at trial was telling her that the bank had no obligation testified at his deposition differently than that. At his deposition, what he testified was the reason you have a loan agreement like this is that it sets out all the terms, and that when the developer meets the terms, you get the loan, and it doesn't have to go back to the loan committee. That's why the loan committee signs off on the loan agreement. That's what he testified at deposition, but he tried to change his tune at trial, and the judge would have none of it. She rejected him as being not credible. Furthermore, the bank's position, in essence, asked the judge to ignore major tenets of contract interpretation. You know, her job was to interpret the contract as a whole, trying to read its provisions together harmoniously, to implement the intent of the parties as expressed in the document. And what the bank is asking, what the bank asked that court to do, and it was rejected, and is now asking this court to do, is to say that none of it matters. Page after page after page of provisions and requirements that my client would have to meet in order to fulfill its obligations under the contract were, according to the bank, without meaning of any kind.
Is there any meaning that you would ascribe to the guidance line that appears in quotes in the letter that predates the loan agreement?
No, sir.
4, I believe.
Here's what I would say about that.
Frankly, counsel, it appears, and we've been kicking this around just because of the oddity of it, it appears that that's not a real term. It appears they're putting it in air quotes because they're trying to ascribe some value to it that we don't get. So can you help us with that?
We do still have to make sure that we interpret contracts to avoid rendering terms superfluous or meaningless. So if there is some meaning that you believe it has, it'd be helpful to know.
All right. So I'd say a couple things on that. You're not going to be rendering any term superfluous by simply ignoring the term in as much as it's not in the contract. So no part of the contract is being rendered superfluous in that sense. And on page 7 of her under advisement ruling, specifically paragraph 49, I think our judge does a good job of tying together what was the meaning and purpose of this contract. And at paragraph 49, she says, by entering into the loan agreement / guidance line, Tier 1 agreed to make loans on a case-by-case basis, provided borrower complied with the terms and conditions set forth in the loan agreement / guidance line. I think she encapsulated it right there. Now,
does a loan agreement / guidance line mean that the terms, I mean, I think we understand generally in the law what a loan agreement is. We don't necessarily understand in the law what a guidance line particularly is. By putting them together with a /, does that mean that they are equal?
No, sir. What's going on is the bank can't even bring itself to say loan agreement. I don't think that the term loan agreement appears in its briefs. Counsel said it today. I'm proud of him. They can't even bring themselves to say guidance line of credit, which is what the January 2008 letter, Exhibit 9, says. And line of credit, by the way, Great Western Bank admits is a committed facility. And it's their letter that calls it a guidance line of credit. But here's what I think guidance line is. I think guidance line is the bank equivalent of making a promise with your fingers to cross behind your back. Because
your client signed that letter that had guidance, that was entitled guidance line.
Yes, sir. And that said in 3 different places that this is a committed line of credit. That's what my client signed. And the next day, my client signed a loan agreement that promised that until December 1, 2008, if we met conditions, the bank would make those loans. Now, Great Western Bank wants to lecture this court on what it believes a guidance line to mean, but it ignores the fact that the loan agreement doesn't use the term. It ignores the fact that Exhibit 9 calls the agreement a line of credit, which Great Western Bank admits is a committed facility. It ignores the fact that Exhibit 9 calls the loan committed 3 different times. It ignores the fact that Tier 1 Bank's vice president testified that the intent of a loan agreement was to prevent loan applications from having to go back to the loan committee.
I understand that. Arguably, Exhibit 4 contains a definition of guidance line, right? In paragraph 1, it says, is a, quote, air quote, guidance line, which is an indication of the maximum allowable amount of loans outstanding that you may have with Tier 1 Bank during the term of the guidance line. Is that it? I mean, is there any evidence in the record that there were discussions about the difference between a guidance line of credit and a loan agreement that might shed light on the interpretation?
I don't think there's any question but that on appeal, the bank wants to talk about what its notion of a guidance line is. It even quotes, I think, some treatise in its brief. It may have been in the reply brief, trying to instruct us on, what a guidance line is. I don't know any about, here's what I know. Here's what I know. That at trial, I argued the contract. There's a loan agreement. It was signed by the parties. And the judge was charged with, first of all, trying to read that contract and interpret the intent of the parties based on the contract's plain meaning. The judge took a lot of testimony and reviewed a lot of documents that shed additional light on what the parties were trying to get after. There was no academic discussion at trial, Judge, about What is a guidance line? Does it actually exist? Is it what controls us here? As in any contract case, the contract is what controls here. And that's what the judge was focused on. That's what we're focused on. And really only in appeal, nothing left, I think, to grab onto is the bank trying to suggest that there's some academic notion of what a guidance line is, and we should all be aware of it, and it should be applied here, notwithstanding what the actual language of the parties' agreement is.
What about a legal definition of what a guidance line is?
I don't know what that would be, Your Honor.
Well, as you point out, it's actually called a guidance line of credit. The term line of credit seems quite significant to both of your arguments, right? Because a line of credit is committed. Was there any discussion at trial about the word guidance meaning essentially not a line of credit or something, an uncommitted line of credit?
There was.
Because without the word guidance, you've got a line of credit, and the case becomes very easy. The word guidance seems to be important.
So, John Crowley at trial did testify to his frustration when he was notified by the bank that they were pulling the line. And trying to save his project, of course, he immediately went out and tried to find financing, and he could not. And we could, and to an extent we did, present evidence at trial from Mr. Crowley about what he thought the agreement was. But that, and by the way, I think that Mr. Crowley, the judge, found to be a highly credible witness. But there are two arguments here. I mean, this reminds me of the Mad Magazine series Spy versus Spy, except in this case, both spies are the bank. One is the predecessor bank and one is the successor bank. The bank's documents say things like, the purpose of this loan is to ensure financing. The bank's documents say that this is a guidance line of credit. The bank's documents say that it is committed. The bank's vice president, at the time of his deposition, said a line of credit is a committed credit facility. The bank's vice president, at the time of his deposition, said the whole reason for having this agreement is to expedite these loans, so you don't have to go back to the loan committee. Okay, so that's Cedar Ridge's argument. That's the borrower's argument at trial as to what is the meaning of this agreement. Then you get to trial, and it's the same witness. I mean, this poor vice president was put in the position of doing an about face. He takes the stand at trial, and now he looks the judge in the eye and says, this agreement was completely discretionary. It was only an outline. It gave my clients exactly no rights that they wouldn't have had if they had just walked in off the street. And here's what happened. His credibility went to zero. He had no credibility at trial, and the judge now, understanding the rules of construction, is faced with trying to figure out, all right, is there a contract that in some level bound Tier 1 bank to make loans, or at least to consider making loans? Or, as is being argued at trial by the same guy, is it a nullity? She rejected the latter argument. She found that, yes, there was a bargain for agreement, and the bank just walked away.
Well, it seems to me like they didn't just walk away. They certainly didn't act under the loan agreement, but they also moved against the A&D non-payment and took that property back in a foreclosure action.
They did, and I regret that I didn't represent this client at the time. I'd like to think that a different result could have been reached, but that obviously is not part of what's being considered here today. But I do think it's important to note this. The stock market crashed in September 2008. I think it was September 29, to be specific. The recession began in the third quarter of 2008, which we only know looking back. This agreement was abrogated 2 months before that. And you can't simply say, well, the economy was terrible, there's no way it could have succeeded, because in 2010, the bank's own appraiser issued a report, this is Exhibit 95001, admitted into evidence without objection, that in this market, in Flagstaff, prices came down a little, houses were on the market a little longer, but from 2008 to 2009, the number of sales actually increased. And this is the market that my client would have entered at the end of 2008. And they were denied that opportunity when this bank pulled the rug out from under them. And I think this judge reasonably found on the facts of this trial that but for this bank's breach, the A&D loan would have been serviced, and not only that, but my client would have made a substantial profit. And all of that laid waste by the decision that Tier 1 Bank made in July 2008.
Thank you, counsel.
Thank you.
We will take this matter under advisement at this time, and a decision will issue in due course.